See Judgment 112 宪判 12, 2023. Principal facts, issues, and the procedure of the case. Article 159-3 of the Code of Criminal Procedure stipulates that statements made in the investigation stage by a person other than the accused to the public prosecuting affair official, judicial police officer, or judicial policeman may be admitted as evidence if one of the following circumstances exists in trial, and after proving the existence of special circumstances indicating its reliability and its necessity in proving the facts of a criminal offense. 1. The person died. 3. The person cannot be summoned or has failed to respond to the summons due to the fact that whereabouts are unknown. Petitioners 1 to 5 of this case were all found guilty in their respective criminal cases in which the witnesses who made the statements against them were either dead, could not be summoned, or failed to respond to the summons because their whereabouts were unknown. In these cases, the court deemed that although the witnesses were unavailable to be cross-examined and confronted by the defendants at the trial, their statements taken by police outside the court were particularly reliable and necessarily improving the offense, thus admissible under Article 159-3, paragraph 1 or 3 of the criminal case of the criminal code. After exhausting all remedies, petitioner 1 to 5 filed for constitutional reviews respectively. Their cases were later consolidated by the court. The petitioners mainly argue that the Article 159-3, paragraph 103 of the Criminal Code of the Code of Criminal Procedure allowed out-of-court statements to be admitted as evidence without being confronted and cross-examined by the defendant in court, consequently violating their right to due process and the right to institute legal proceedings guaranteed by Article 8 and 16 of the Constitution. In addition, petitioner 4 and 5 also motioned for preliminary injunctions to hold their execution. Decision of the court. The TCC upheld the constitutionality of the disputed provisions. The TCC emphasized that the disputed provisions constituted no violation of due process and the right to judicial remedy under Article 8 and 16 of the Constitution, so long as the defendant is given a balanced right to confrontation during trial, and that not confronted, not cross-examined, out-of-court statement cannot be admitted as the only or decisive evidence for the crime, so there is a need for corroboration. The TCC denied the preliminary injunction requested by petitioners 4 and 5.